Hello everyone. In today's video, I will discuss the topic types of contract. Contracts are broadly classified into three categories on the basis of enforceability, on the basis of formation, and on the basis of performance. On the basis of enforceability, there are 5 types: valid contract, void agreement, void contract, voidable contract, and unenforceable contract. On the basis of formation, there are 3 types of contract: express contract, implied contract, and quasi-contract. On the basis of performance, there are 4 types of contract: unilateral contract, bilateral contract, executed contract, and executory contract. In today's video, I will discuss the types of contract classified on the basis of enforceability. The first one is valid contract. Valid contract is an agreement which is enforceable by law. An agreement becomes a valid contract when it satisfies the conditions given under Section 10 of the Indian Contract Act, such as free consent, capacity of the parties, lawful consideration with lawful object, etc. I have already discussed the conditions of a valid contract in my previous video. If a party enters into a valid contract, then he or she has the right to take legal action against the other party who fails to perform his legal obligation. Let me explain this point with an example. Pradeep borrowed rupees 80,000 from Rahul. Rahul was a money lender. Pradeep agreed in writing to repay the loan on 31st March 2016. So this is a valid contract between Pradeep and Rahul. If Pradeep fails to repay the loan on the due date, Rahul may take legal action against Pradeep. Next point, void agreement. The term void agreement is defined in Section 2, Clause G of the Indian Contract Act. As per this section, an agreement not enforceable by law is said to be void. An agreement with unlawful consideration or object is a void agreement. An agreement with a minor or with a person of unsound mind or a person disqualified by law is a void agreement. An agreement in restraint of marriage is also a void agreement. Void agreement is void ab initio. Void ab initio means void from the very beginning. Example: Mr. Tom was so drunk that he could not understand the terms of the agreement and could not form a rational decision. During the drunken state, he entered into an agreement to sell his car worth rupees 2 lakhs to Mr. Bob for rupees 10,000 only. But later on, Tom refused to hand over the car to Bob. He said to Bob, "I was not in a sound mind at the time of the agreement." Next point, void contract. The term void contract is defined in Section 2, Clause J of the Indian Contract Act. According to this section, a contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. A contract which is enforceable by law at the time it was made, but later on it becomes unenforceable due to some reasons, it is called void contract. Example: Sanju and Madhu promised to marry each other. They had an agreement that they would marry on 25th December 2012. But before the due date came, Sanju died in an accident. In this case, the contract becomes void on the death of Sanju. So it is not enforceable in the court of law. Next, voidable contract. The term voidable contract is defined in Section 2, Clause I of the Indian Contract Act. According to this section, an agreement which is enforceable by law at the option of one or more of the parties thereon, but not at the option of other or others, is a voidable contract. Example: Karan threatened to kill Arjun's son if Arjun did not sign a promissory note of rupees 80,000 in favor of Karan. Arjun signed the promissory note under the threat. In this case, Arjun's consent was not free. When the consent is not free, then the contract is voidable at the option of the party whose consent is not free. Now we move on to the next type of contract, that is unenforceable contract. Unenforceable contracts are those contracts which satisfies all the requirements of the contract, but due to some technical defect, it becomes unenforceable in the court of law. Such contracts are enforceable if the technical defect is removed. For example, if a document requires to be stamped in rupees 1,000, but if it is done in rupees 50 only, we called it a technical defect. But if the required stamp paper is affixed in the document becomes enforceable. So these are the different types of contract which are classified on the basis of enforceability. That's all for today. Thank you very much for watching.